time for questions at the end, if that's all right with everyone.
Sure, go for it.
All right, thanks so much. So good afternoon. My name is Karen Ferridan. I'm the founder of Berks Gas Truth and co-founder of the Better Path Coalition. And we're really excited to have all of you with us today to talk about Article 1, Section 27 at 50. We have Maya Van Rossum, who I'll introduce in a minute, who will take care of other introductions, but her organization, the Delaware Riverkeeper Network, and Green Amendments for the Generations have both been partnering with the Better Path Coalition and putting together today's event. And so I have a couple of pieces of business I just want to cover quickly before I turn things over to Maya. For one thing, we're going to be recording, we're already recording the session. And so we're going to ask everybody to remain on mute throughout so that we have nice clean recording and everyone can hear. So please, if you're not on mute and I mute you, please forgive me. And then the other thing I wanted to mention was that we are reserving time at the end of our presentation today for questions and answers. We're going to give preference to questions submitted by legislators and their members of their staff, since this is a legislative briefing, but we'll try to get to as many questions as possible. So put them into the chat, please. And please, for today, reserve chat for questions so they're easy to spot, and also so that we have fewer distractions during the presentation. And so thank you again for being with us today. And now with that, I'm going to turn it over to Maya Van Rossum, the Delaware Riverkeeper and founder of Green Amendments for the Generations. Take it away, Maya.
Great. Thank you so much, Karen. You know, the Better Path Coalition is a key leader and partner in advancing Article 1, Section 27 here in the Commonwealth of Pennsylvania. And Delaware Riverkeeper Network and Green Amendments for the Generations is honored to partner up in this important work. As you all know, it's 50 years ago that, because of the vision and the leadership of Senator Franklin Kury, Pennsylvania voted to add Article 1, Section 27 to the Pennsylvania Constitution, recognizing the constitutional rights of all Pennsylvanians to a clean and healthy environment, and the obligation of state government to protect Pennsylvania's natural resources for the benefit of all the people of the state. The addition of Article 1, Section 27 to the Bill of Rights was a turning point for our state. With Article 1, Section 27, we could now ensure that our rights as people to the healthy water, air, and environments necessary for all Pennsylvanians to live, to survive, and to thrive would be given the same constitutional recognition as the other fundamental human, civil, and political rights that we hold dear. While securing proper interpretation and implementation of the constitutional right took a few decades to get right, with the leadership of Senator Curry, the Chief Justice of the Pennsylvania Supreme Court, Ronald Castile, and the important legal team of Jordan Yeager, John Smith, and Jonathan Kamen, along with organizations like the Delaware Riverkeeper Network, Green Amendments for the Generations, and the Better Path Coalition, we are now doing the important work of fully and fairly understanding and securing the environmental rights promised by Article 1, Section 27. And so with that, I am honored now to introduce Senator Franklin Kury, whose leadership has ensured that all the people of Pennsylvania can be confident and secure in the knowledge that their rights to pure water, clean air, and healthy environments are receiving the constitutional respect and protection they both need and they deserve. Senator Kury?
Well, Maya, thank you very much. And ladies and gentlemen, members of the legislature and their staff who are attending, I'm delighted to participate in this program. And what I'd like to do is describe how this amendment came to be, how it was adopted, and what the courts did with it up until the time of the Robinson Township Delaware Rivers Keepers case. So let me start with the beginning. Actually, she calls me senator, but all of this happened while I was in the House. It all began in 1965 when the state legislature voted on House Bill 585, which was a bill to bring the coal companies under the Clean Streams Act once and for all. The state had passed 4 Clean Streams laws since 1905, And in every one, the coal industry got an exemption or special treatment. So in 1965, people were getting very upset. The environmental movement was just beginning to rumble, and this bill came up for a vote. And the incumbent from my district, who was chairman of the Appropriations Committee, a senior member, been there 20 or 25 years, voted no, 1 of 6. It was incredible. Well, one of the leading environmentalists of the area, Bessie Beck, was following this. He said to me, Franklin, you run for the House and I'll be your campaign chairman. So in 1966, I ran for the House. I had no idea of constitutional amendments. All I was thinking of was cleaning up the Clean Streams Law, making it comprehensive, and being sure our area had a clean streams spokesman. Every town in my district, which is Watsontown, Milton, Sunbury, Northumberland, Danville, every major community in my district, which is 108. Every community was on the river. So when these fish kills came down, and they did, 65 people saw it. It was a red hot issue. And I ran, and I was fortunate enough to win. I ran 5,000 votes ahead of Schaaf, beat the incumbent by 950 votes, and took our seat in the State House of Representatives, which was stunning. And the important thing then is the environmental revolution was just getting started. House Bill 585 was the first step. But in 1968, I was reelected, and then the Democrats took control of the House Conservation Committee. John Laudadio became its chairman, and I became its secretary. And in the next 4 years, we considered more environmental bills than in the history of Pennsylvania combined. I couldn't believe it. Now, I didn't have much to do with most of these bills. I didn't write most of them, but I was in the middle of the committee, and our committee passed on all of them. They had to go through our committee, so I was a good lawyer, and I tried to read all of them and understand it. It was quite a show. We passed a Clean Streams Bill, Clean Air Bill, a strip mining law, mine disposal law, waste disposal, all kinds of, about 7 other bills. It was absolutely stunning. And in the middle of all this, I was having coffee on my deck one morning. I saw in the New York Times that the New York legislature people were going to pass an amendment to the New York Constitution to protect New York's forest lands. And I said, my God, why doesn't Pennsylvania have something like that? We have nothing like that. Now, New York law was limited to forest, but the idea struck me. Well, then I went back to my law school days. I had a good course in constitutional law at Penn, and I had a good course in trust law and some other things. And I began to write this idea of putting these ideas into writing, because I knew that these bills we were passing, all these 10, 12, 15 bills we were passing, could be repealed or reduced in years ahead. We need something stronger, more permanent. So it all came together. And in 1969, I introduced in the House a bill which had 3 basic principles. One, the people have a right to a decent environment, healthy environment, clean air, pure water, and so on. That's the first thing, a healthy environment. They have a constitutional right to that. Secondly, the public natural resources, like the rivers and the air, belong to everybody, not just the coal companies. Some of these coal companies treated the rivers as if it was their private discharge system. All that was gone. And the third thing we did was make the state the trustee of natural resources for future generations. Now, that's the way the bill was introduced in 1969. And it received 4 amendments the first legislative session, 1 in the House and 3 in the Senate. And it came back to the House on April 14th, 1970, with 3 Senate amendments. And that day, Speaker Feynman made it Earth Day in Pennsylvania House of Representatives. And the main speaker for the day was Senator Gaylord Nelson of Wisconsin, who was touring the various states promoting the first Earth Day, which actually occurred a week later. But this was the only day he could be in Pennsylvania. So in Pennsylvania, we jumped ahead of the full Earth Day by a week. Anyhow, in the program, one of the first things was the speaker called on me to move approval of the Senate amendments, which I did. And my motion was seconded by Bill Wilt, the Republican chair of my committee of the Conservation Committee. So that we approved that and set it up for passage later. And of course, then we have Senator Nelson's speech. And by the way, in my book, which Maya will describe later, in my new book on the 50th anniversary, I have in the appendix the House Journal for April the 14th, 1970, so everybody can look at that and see the proceedings, see the roll call, and see Senator Nelson's speech. So that happened then. The next year, in 1971, in January, I reintroduced the bill. And it passed both houses in February. And it was on the ballot in May 18th, 1971. It was stunning how fast it moved. Nobody opposed it. Both parties strongly supported it. I said it wasn't blindly approved because there were 4 amendments, but at least there was no outright opposition. Well, when it came on the ballot, we had the support of the Pennsylvania Federation of Sportsmen's Clubs, which at that time was the strongest environmental group in the state. The Pennsylvania League of Women Voters was strongly for it. The Pennsylvania Bar Association was for it. And of course, the newly founded Pennsylvania Environmental Council, led by Kurt Windsor, was for it. So with all of that, the ballot was voted on May the 18th, 1971. And I'd like to point out that there were 5 constitutional amendments on the ballot that day. 2 of them were defeated. The third one had to do with jury selection. That passed narrowly. The next one was women's rights, equality rights on gender. That passed 2-1. But then the environmental amendment was first. That passed 4-1. It was absolutely stunning. And I keep kidding my wife ever since that environmental rights were twice as popular as women's rights. But I mean that only in jest, because obviously both were serious. But it was afforded. People of Pennsylvania really spoke out on this. They looked at all 5 proposed amendments. They got rejected 2, and they voted on the other 3 accordingly. But I couldn't get over that. It was absolutely stunning. So that was the high water mark of public support for the environment. Well, shortly thereafter, with the amendment on the books, the Governor Schaap brought the Gettysburg Tower case, which he tried to block the building of a private tower on the Gettysburg battlefield. By the way, Governor Schaap's the only governor who personally who took a lawsuit to carry out the amendment. He lost. The Gettysburg Tower case, he lost, except for one thing. The courts ruled that the amendment is self-executed. What that means is you don't have to have another law by the legislature authorizing people to bring lawsuits to implement that. That was strongly argued, and the courts rejected that. They said, no, you don't have, this is self-executed. So that was a good thing about it. But then a year or 2 later, the courts dealt an even more severe blow to the amendment with the Payne versus Cassava test. This was a case out of Luzerne County, where the State Department of Transportation wanted to take 1/3 of an acre of land in the Wilkes-Barre Commons for a bridge. And Marion Payne, a prominent civic leader in Wilkes-Barre, brought a lawsuit against the Cassava was Jacob Cassava, Schaap's Secretary of Transportation. And that case went all the way to the Supreme Court, and they rejected her case. And they set up a 3-part test for whether or not the environmental amendment was violated. The first test was, did the developer do everything he could to reduce damage to the environment? Secondly, did the developer comply with every environmental law? And thirdly, did the benefits of the project outweigh the environmental damage? Well, that was the Payne-Cassava test that was law for almost 40 years. And people thought the amendment was virtually deceased. I considered it anesthetized. But to make a long story short, in 2013, things changed rapidly. Robinson Township and the Delaware Riverkeepers and others brought a lawsuit challenging the oil and gas law that was passed for shale gas. And that went to the state Supreme Court, and Justice Rod L. Castile changed the whole world forever. He recognized that everybody else recognized. The Payne versus Cassava test had no relationship to the language of the amendment. Nothing to do with people's rights or the public ownership of the natural resources or trustee. His declaration, which will live forever in my mind, is to the courts of Pennsylvania, read the English language. And when you interpret Article 1, Section 27, use the plain English language. And with that, the court declared unconstitutional 2 sections of the oil and gas law. Most prominently the one on zoning, which the legislature had authorized the oil and gas companies to override local zoning. That was knocked out. Another was knocked out. Castile also cast grave doubts upon Payne versus Cassava. The problem was that this was only a plurality opinion. You need 4 votes to make it a majority opinion. He did not have that because there was a vacancy in the court and the court was split. But he had enough with Justice Baer's concurrence in the result that this was a plurality opinion. But it still shook the world. And a year or 2 later, another case came up with the Pennsylvania Environmental Defense Fund, argued by John Childs, a lawyer in Dauphin County. And this time, the court affirmed everything Castile said. They threw out Payne versus Cassava, and they put Article 1, Section 27 in full vigor where it ought to be. And that's the way it's been ever since. But those 2 cases, the one brought by Robinson Township and the Delaware Riverkeepers, and then the PEDF case, those 2 have now put the amendment back where I think it's safe. How could anybody say you don't read the English language and apply it? So that's where it is. Now things have changed a lot, and I could go on and on, but I'd be glad to answer questions, and I'll just yield to the next speaker.
Great. Thank you so much, Senator Curry. And we will have time at the end for questions and answers. But now I'm honored to introduce John Smith. John is a partner and co-founder of the law firm of Smith and Butts. John was one of our lead attorneys in that landmark case, Robinson Township, Delaware Riverkeeper Network versus the Commonwealth, that Senator Curry just spoke about. And that's the case which for the first time laid the foundation necessary for us all to understand the rights and obligations confirmed by Article 1, Section 27 of the Pennsylvania Constitution. Since that landmark decision handed down in 2013, John has represented municipalities and the public in their efforts to fully, fairly, and properly understand, interpret, and implement Article 1, Section 27 of the Pennsylvania Constitution. John?
Thank you, Maya. And thank you to Franklin Kury. It's always fascinating to listen to Franklin, and I appreciate, just from a historic perspective, your willingness and ability to go out there and explain how these constitutional amendments or even laws came to be. And unfortunately, in today's environment, I'm not sure that Pennsylvania could pass what you got passed. But nonetheless, thankfully, it's in place. And while it was ignored for a great period of time, as Senator Curry pointed out, in the Robinson Township Delaware Riverkeepers case, the court finally put the hammer back into the constitutional amendment. Now, what Mr. Curry did not bring up, which I think is important, is in our Pennsylvania Constitution, as to all of the elected officials that have to comply with it, it could have been placed in a number of different sections. It was placed in Article 1 of the Pennsylvania Constitution. That is our Bill of Rights. So what that means is that all of those rights set forth in Article 1 of the Constitution, that the citizens retain those rights. And I think because it's a little easier to understand, and because we see it more often, the right to bear arms, the right to free speech, those are in the United States Constitution Bill of Rights as well. But we understand that those rights cannot be taken from people. But we've never seemed to equate the right to clean air and pure water along the same stage. And that's what needs to happen, because that's where it is placed. It's placed in Article 1. So in the Robinson Township Delaware Riverkeepers case, we saw really for the first time other than the Gettysburg case, the attack on the state legislature, the attack on a state law. And the state law that was put in place required what we believe to be violations of the citizens' constitutional rights to clean air and pure water, and of course, violations of Article 1, Section 1 of the Pennsylvania Constitution. So within that case, the court sided with us and found that as legislators that you did not look, the individuals that passed the law did not look or consider the environmental rights of the citizens when they enacted the law and put the law in place. And that you could not just do a statewide law that says that every municipality has the same the same obligations or conditions. And for instance, the right to clean air, how far emissions might travel from a certain site may depend upon wind conditions and environmental features and hills and valleys that are unique to the various areas. So a law that may be protective in Pittsburgh may not be protective in another part of Pennsylvania. And Justice Castile struck that down. Now, what Mr. Curry also foreshadowed was what happened because it was a plurality decision, the case got kicked around a little bit. Courts were reluctant to follow because it wasn't a majority decision, sort of drifted back to what he explained to be the Payne test. And in the Payne test, provided this more balancing test in trying to implement the law. So throughout the years, there have been cases, and I say years, I can't believe it's been that long, and it has since 2013, but there have been a number of cases that have gone forward, and PEDF being the most prominent, where finally a majority of the Supreme Court adopted the Robinson Township rationale. And I think, I don't like to quote case law, but I think it's important to understand that the right to clean air, again, is recognized in Article 1, Section 1 of the Constitution of the people's rights. There's also the PEDF court spelled out, and I guess in the question and answer, I'm curious if Senator Curry agrees with the PEDF, how they define the trust obligations, because here we have really for the first time in the Constitution, a mix of trust law, placing the trustees, the elected officials in that role. And the court held that Pennsylvania's environmental trust thus imposes two basic duties on the Commonwealth as the trustee, and of course our elected officials sitting as the trustees. First, the Commonwealth has a duty to prohibit the degradation, diminution, and depletion of our public natural resources, whether these harms might result from direct state action or from actions of private parties. So the court has read into this amendment, the plain language, interpreted what your obligations are as elected officials to prohibit the degradation, diminution, depletion of the natural resources and the harms that might result. Now we get this question, Maya and I get it all the time from other states. Well, does that mean we can't do anything? And the answer is no. Obviously, there's the ability to extract, there's the ability to adapt, but I think there has to be a conscious understanding that you cannot, in doing so, affect people's right to clean air and affect their right to pure water, where Senator Curry pointed out what he saw was the dumping in the rivers, that was their disposal system, and you can't do that. So as elected officials, recognizing that the obligation is on you to make sure that if a law comes up, these questions need to be asked, how are we not policing these rights? How are we protecting these rights and making sure that no harm results, or that the harm results can be minimized such that it doesn't necessarily cross that line to a violation of clean air and pure water. And the second part, the PEDF court found that the elected officials have an obligation as trustee, is that the Commonwealth must act affirmatively via legislative action to protect the environment. So while it is a self-executing amendment, meaning the people have the inherent right to clean air and pure water, and the state cannot take that right away by allowing uses to go forward that would abridge those rights, the court went further and found that the amendment itself provides that you have to draft legislation that will further those rights, whether it be through air testing or whether it be through setbacks at the local government level. Those are things, whether it be by strengthening the Clean Air Act or the Clean Streams Act, making sure that dumping in the rivers won't affect people's a right to that water. And we do see, obviously, water concerns and air concerns throughout the Commonwealth. So recognizing that this amendment requires some affirmative duties on the legislative body is important. Now, the other thing I wanted to speak about is where I see this on a more daily basis, that we bring these more to the local government who are enacting laws, and we take issue at certain levels, be it at the court level, being at the municipal level before their actual bodies, as to what obligations they have. If an applicant in passing an ordinance, should they make sure that when they put setbacks in place where you can put a cement factory in, but it has to be 500 feet from a residential home, or a unconventional drill site 500 feet from a residential home. Well, the 500 feet might be an absolute good faith effort to say, well, that's fair, but it's got to be based on the right to clean air, and it can't be arbitrary. So we argue that you can't create these laws and these setbacks that are in place to be protective of public health in a vacuum, that you better have some support for that you better be able to back up the rationale that you employ, that setback is actually adequate. Or if it is not, then you may run the risk of running afoul of Article 1, Section 27. We also see it on the flip side. Let's assume that we have an ordinance in place that's 1,000-foot setback, and that setback was in good faith put in place, and an applicant comes in. The obligation at the local government level before they approve an application is, can you meet that setback? That's easy. I can set my site up 1,000 feet from your location. But will your air travel further than that? Will your potential harmful emissions, volatile organic compounds, hazardous air pollutants, noise travel beyond that distance such that it will affect people's right to clean air? And there's a real fight as to what role the municipal bodies play in that regard, in terms of they act as a quasi-judicial body, but they don't want to act as objectors. But that being said, we believe that the constitutional amendment, the right to clean air and pure water, makes the municipal or any elected official understand what is going in place before they can act. So approving a use is a government action. And in my position, in my opinion, is that a government cannot approve a use, approve an ordinance, approve an application without knowing how or whether the right to clean air and pure water will be affected. So that is something that we see every day, and we're looking for the state legislators to employ a similar understanding, whether it be bringing in industrial hygienists, toxicologists, saying, if we allow this use to put in place, can we regulate the technical features such that it will not affect these people's rights? Understanding that the applicants would rather have less regulations in terms of it's cheaper, but you have this constitutional right and Article 1 Bill of Rights sitting there as a stop against such activity. Now, lastly, what I've recently put before the Commonwealth Court last week in an argument on a Article 1, Section 27 case, and I'm not sure Senator Curry has spoken to this, but because Robinson, Delaware Riverkeepers Court and PEDF have recognized that there are trust obligations by the trustee and the elected officials being the trustee. Typically, if an elected official passes a law and we would challenge the law, whether it be at the state or local level, you are immune from having to be deposed or having to testify to explain what you did under the law, because you have the right as legislators to make decisions that you believe are in the best interests of your constituents and follow the law. So the court has protected and shielded legislators from having to testify or answer for their legislation. But what we've asked the court to do is allow us to take testimony and or depositions from elected officials because they are trustees. And under trust law in Pennsylvania, trustees have the obligation to come forward and explain what they did in furtherance of their beneficiaries' rights. And in this particular case, the lower courts have denied our ability to question the local officials, basically under their Article 1, Section 27 obligations as a trustee. My clients as beneficiaries want to know what they considered and what they did to further the protections under Article 1, Section 27 that they owe the beneficiary to further their obligations as the trustee. So the case law and trust law says that the trustee absolutely has to answer to the beneficiaries. It'll be interesting to see how and when the court addresses this, whether legislators have to then answer for their conduct and whether they are working in compliance with Article 1, Section 27. Because as of right now, they can pass a law like Act 13 that runs roughshod over Article 1, Section 27 and not have to personally answer as to why they did it or to support why they did it. I have had occasion to get to local officials and I say, why did you pass this law? What does this mean? Are people protected? And the answer is typically they don't know. And that's not a good answer under Article 1, Section 27. Well, I'd rather be more pinpointed in my responses to any questions. So I'm going to cut my time short and be available with Mr. Curry for questions as we go forward.
Thank you so much, John. That was really helpful. So now we're going to just go to our last piece of the presentation before we go to Q&A. And that is going to be a video clip. Last year, I had the honor of interviewing the former Chief Justice of the Pennsylvania Supreme Court, Ronald Castile, who did in fact pen that landmark case that you've heard so much about, Robinson Township, Delaware Riverkeeper Network versus the Commonwealth. This is the decision which for the first time helped all the people of Pennsylvania, including legislators, lawyers, justices, and the public, understand why and how Article 1, Section 27 should be interpreted using the same legal principles and values as we apply to all the other Bill of Rights amendments, as John just spoke about so eloquently. So we wanted to share with you a few minutes of that interview. This section of the interview includes a message that we think is particularly relevant for the legislative leaders of our state. So with that, we're going to roll the video. Principles, constitutional principles, legal principles give you as a justice the tools you need to figure out in one context or another whether that right to pure water and clean air has been breached.
That's the division of authority between the legislature and the judiciary. We say that the act is unconstitutional. You go back and then it's up to you as a legislature. You're representing the people. It's up to you to decide if the water is clean enough or if the air is clean enough, the specifics of that. And we don't get into that. In fact, there was some challenge after this Robinson Township was passed. The legislature said, well, what's the test? They wanted us to give them a test. We're saying, that's not up to us. So you are the ones that have to figure it out. And, there's all kinds of statutes on the books, especially in the federal level, that will tell you, what is violating the Clean Air Act by certain particles per million, things like that. And that's the job of the legislature and the executive. It's not us. So we didn't give them a test. We said well, it says you're the trustee of this important properties of the state of Pennsylvania, and you have the duty to make sure that you properly, as trustee, manage that. So what happens is they'll pass something, and the legislature and the governor will sign it and come back up to us, and then we decide if we're even going to hear the case at our level. But we decide if it violates any other statutes or the Constitution. But the actual hands-on, dealing with what is clean water, how many parts per million can you have of gasoline water, things like that, or the smog in the air, so that's on them. So we're not going to do that. We're not equipped to do that. That's the executive and the function, because they see a stream and it's black with coal dust. They say, well, they can say, well, that's clean water, but somebody's going to fight that. And there's all kinds of lawsuits over amendments, you know, on the clean water, clean air, all these different things. I've had to write an opinion about how much mercury you can have in parts per million in a cubic yard or something like that, and how much you could have was actually decided by the legislature. So it wasn't decided by us. So that's how it works, and but we're just not equipped to be the persons to be on the ground, you know, at the side of the stream.
So you make sure that they've looked at the science, looked at the facts, looked at that there was a grounding for their decision, that they fulfilled their trustee obligations to treat everybody equitably, right? Or to fulfill their duty of loyalty to all the beneficiaries. And you make sure they sort of followed the rules in deciding what's clean water. Is that?
Right. Yeah, we don't write the rules, but we say, we discuss the legislation and we say, like, this violates, you know, the Environmental Rights Amendment, and you guys go back and decide, you know, go back to the drawing board basically, and you know, I think you could put one of these wells like 300 feet from a building, which is only the size of a football field. So we didn't put that 300 feet in there, you know, and we didn't say that 300 feet is unconstitutional. We just said the whole thing is unconstitutional. So they could come back and say 150 feet or 300 feet or, you know, 1,000 feet, and that's their job, and then it's our job to determine if that's if that, you know, is congruent with the statute and the amendments.
So one of the things that we hear in states where they're considering a green amendment is if you add a constitutional environmental rights amendment, there's going to be a massive influx of litigation. Lawyers are going to come from everywhere and bring lawsuits. And I'm just wondering your reaction is to that.
Well, that's this thing here. I mean, it wasn't the environmental rights amendment that caused the litigation. Is what they did to the fracking that caused it all. So, yeah, it's brand new. So, yeah, it's going to be tested. Any law that's passed is going to be tested. You know, unless 100 people, 100% of the people agree with it. You know, and it still may be tested. Who knows? But yeah, there's going to be litigation involved, and it's a pure example here. But you know, we did what we had to do as a court. They did what they have to do as the industry, and then the people did what they had to do. So it was pretty settled after this that they have to go start all over again.
So that, I just want to say, that is like the best answer ever, and I'm going to adopt it. The answer of the Environmental Rights Amendment didn't cause the lawsuit. Act 13 caused the lawsuit. I love that. That's really great. The other thing that we hear about in opposition is that if you pass an environmental rights amendment, if you have an environmental rights amendment added to a state constitution, all economic development is going to shut down. Nothing is ever going to happen again in the state in terms of economic growth. And I'm just and they're pretty like absolute about that. And I'm just wondering what your reaction is to that opposition.
Yeah, I mean that's the extreme. You know, that's the end of the earth, the end of the world kind of argument. This is going to happen, and you know, you try and take it out to its illogical extremity, which is what you're just talking about. It's not the end of the world, you know, and it's not. You know, it's not. It's like the gun rights. You know, if you modify some of the gun rights, the gun people say it's a slippery slope, and they're going to confiscate your guns, and but that seems to never happen. So.
So now it's time for our question and answer period. And thank you to Senator Curry. Thank you to John Smith. And thank you to Maya for sharing part of that video with Chief Justice Castile with us. So we do have a number of questions that had come in prior to today's event. And those were the ones that Maya was sharing in the chat. So I'm just going to go through them in order, more or less. I'll see if there's anything that we want to make sure we touch on. But let me start with the first one. Legislators often express concern that Article 1, Section 27 is or will result in a massive amount of litigation, including frivolous litigation. Has that been the result? I don't know who wants to take that one first. Maybe Senator Curry? Is that your perception?
First of all, as Justice Castile said, the constitutional amendment didn't create the litigation. It's the cases, it's what's happening on the air and the land and the water. Now, as to frivolous litigation, that's thrown out by the courts. No respecting lawyer is going to take a frivolous case to court because it's going to be thrown out. You have to have something going for it before you file a lawsuit. So I think that's a very weak argument.
John, do you have anything to add?
Yeah, I agree. I think what they're missing here is nobody's asking them to recreate the amendment. They're asking them to, when you're creating legislation, to be mindful of the amendment. And so whether litigation will come or not come, if like Act 13, they were not mindful of the amendment. So there was a lawsuit filed and the legislation was overturned. So here, what we're asking the legislators to do is to be mindful of the amendment, to pass laws in keeping it in practice so that it doesn't violate it, so they don't have lawsuits, or if they do get sued, that they can withstand that challenge by saying, no, look at what we did.
Yeah.
Great. And this is related, it follows from it. How do the terms clean air and pure water get defined? What role is the role of the legislators versus the role of the courts in all of that?
And I think Justice Castile, and frankly, maybe weigh in too, but he just explained that the legislature defines that. And we do have in the Clean Water Act, and I have a number of water contamination cases. So you're looking at different parameters as to what is potentially safe in drinking water, what is not safe in drinking water. You know, we may dispute what that looks like in terms of ingestion. And that's where, you know, scientists can come in because we learn more each day. So as to what that standard is, to me, it's I think even what Chief Justice said, it's a health-based standard. At what point are we going to cause negative health effects to people, and at what distance? So that is where they need to look, and the science is out there. I mean, industrial hygienists is a whole science at the workforce as to how long workers can be around certain things for a certain period of time. And where in an oil and gas case where I have more experience, we had instances where workers weren't allowed to be around certain chemicals for more than 8 hours a day for duration, but the people that were out raking their fields were there for 20 hours a day, 7 days a week, and nobody studied them or nobody considered what was going to happen to them if you allowed this use to go forward. So what I would say is that we look to the science, we look and see what is harmful, and we look at technology. As we know, we can curb some of those emissions. There are certain things we can do to make sure that we don't even need to have that, you know, looking at this, because these emissions are benign or these are not harmful, or they don't flow at that distance.
Let me just say that, for a back of what John has just said, that when the amendment was being drafted and proceeded through the legislature, I deliberately wanted the language to be broadly stated basic principles, not specifics like you have in legislation. And the reason was we wanted a broadly based principles that would last forever, just like the First Amendment to the U.S. Constitution is broadly stated. And that was the idea. We could have been more specific, but that wouldn't last as long, and it would be much more brittle. Now it's up to the lawyers and the legislators to figure out some of these things, but that was intended.
If I can, Karen, I wanted to say, so one challenge along what Franklin was saying is, I recently challenged a setback, and it's at the Commonwealth Court level, where a task force was put in place, similar to the state does this. And the task force recommended that this use was safe from homes at a distance of 1,000 feet. And that was what they came up with. And the legislature looked at it and said, well, if we do that, if we follow that from a public health standpoint, we won't be allowed to have enough of that use. So let's knock it down to 750 feet. And I challenged that and said, well, wait a minute. You can't have a law that is supposed to jive with and comply with the right to clean air when you know that people at 1,000 feet may be protected, but at 750, they're not. And so that's one of the challenges. So how do we set that? I look to science, I look to what they came up with, and that was what the argument, they didn't follow it.
You know, there was just a press conference an hour before our briefing began that addressed setbacks. And there is legislation being proposed now to establish 2,500 foot setbacks, 5,000 foot setbacks. I'm wondering if there will be challenges that come up as a result of that, because there's other science that says there's no such thing as a safe setback. Do you anticipate there being attempts like that in the future to just keep increasing setbacks rather than address the underlying problem?
Well, right, and I guess that's the real question. If first of all, is once we start to learn at whether it be drill sites or other things, what are the chemicals? What are we actually testing for? What is in the air? What are the volatile organic compounds? How far do they travel? Right, those are the seminal questions. And at what point, from a toxicology standpoint, do they harm public health? Then the setbacks can either be enforced or challenged, because, hey, you know, Maryland, for instance, on fracking says the state of Maryland, 2,000 feet is a safe distance. We don't see anything like that in Pennsylvania. They're using the same thing, same drillers, same ideas, but there's this, you know, as the senator pointed out, there's this pain versus Cassava mentality that's still hanging around. Let's do a balancing of feasibility versus environmental rights and rights to make money. And unfortunately, that's where we are. Now, the good thing is, and not to pick on drilling, this isn't a drilling, but from an unconventional drilling standpoint, they can drill up to 4,000 feet away horizontally. So they don't need to be on top of you. Oftentimes we see them, it's cheaper to be right off the road and right in the location. And it may be more expensive to cut in and go another half mile back. But, you know, it's always about expense, not necessarily feasibility.
Anything to add, Senator Curry?
Well, going back to the idea that the basic principles are broadly stated. The real driving force behind the amendment was the public's reaction and my reaction to what the coal companies, the steel companies, and the railroad companies had done to the state for the 100 years after the Civil War. They really raped the state environmentally. Now, in the amendment, we don't mention the coal companies. We don't mention the steel companies and the railroad. We keep it broad. Now, at that time, climate change was never heard of. And the beauty of having the broadly stated principles, they are applicable now as we fight climate change, which has become the #1 issue facing the state and the world, in fact, is because climate change. And the basic principles of the amendment can be used to fight that climate change.
And that was going to be my next question. That was one of the ones that was asked. And I wondered, John, if you have anything to add to the climate part of that issue, what our amendment can do to protect us as we fight climate change.
Right, and I think with everything, you know, the more the science is out there on climate change, it may not be as per use, but it is in terms of different emissions. When we look at the Clean Air Act as to what you're allowed to emit, and you know, oftentimes, just to step back from the Clean Air Act, we know that some of the emissions are premised upon pollution standards, but they're not necessarily studying what those pollution standards are doing to people next door. But from a climate change standpoint, I think this is where the legislators at the Commonwealth level really supersede the local level in terms of they can do things from a big picture standpoint. They can recognize that if we limit this or we mandate technological features, that we have the ability to do that. In fact, to my earlier point, and I think as Senator Curry pointed out, we have the obligation to do it. That's the difference here. This is not an enabling statute. This is Article 1, Section 27. People's right to clean air and pure water can obviously be affected by droughts and everything else that come with climate change. So the legislature have the obligation to draft laws that look to protect those rights.
And that is one of the things that, and it was a question that was asked, but it's one of the things I think a lot of us and the general public wonder about, and that is, we have a confusion about the fact that we have these environmental protections in the Constitution, and yet it's possible that environmental damage keeps being done. What can we be doing to safeguard ourselves, uphold our own protection of, that is guaranteed in the Constitution?
Well, I wasn't on the 11 o'clock call, but I was involved in part with that grand jury investigation. I will tell you first and foremost is the DEP is underfunded, and the DEP, in my opinion, lacks the willingness and the ability to enforce the laws as they're written right now. So if they would actually do their job, we would have a much tighter control and much more compliant pool of people or businesses on our environmental laws. So that to me would be the step in the right direction. Of course, every year, their budget is cut more and more, and they're asking to do less and less. So much so where I went to a seminar where the DEP said, we've just told different industries to, self-police, self-report your problems. Yeah, good luck with that. That happens.
And so is that how it's enforceable, by having lawsuits? How are our constitutional protections enforced if we don't have regulators to do it, if they're consistently underfunded, as you said? How is something like that enforced?
Well, I mean, in my opinion, that in part, that was what the grand jury's obligation was there, the duty to hold people accountable. Now, based on what I knew, I was hoping that there would be certain indictments of government officials who were looking the other way. That didn't happen, but obviously the report speaks to what I said. There was a lack of willingness to enforce the laws, to cite people for whatever reasons. Often, it just didn't happen. But so yeah, lawsuits are a part of it in terms of you bring lawsuits. I have clients who have sued the DEP and sued the DEP to get a court order to have the court order the DEP to do their jobs. So that's one way to do it. But here is it from an oversight standpoint, and I didn't get to see the Attorney General speak today, but hopefully that the state legislators take the ball and run with it and do something about the oversight or the enforceability of the laws. Because when businesses know they have to comply and there are repercussions, they tend to do it. But just like everybody else, if there are no repercussions, or you're going to make them pay $1,000 fine, that's lunch. That minimal cost is of no consequence, and they'll make more money doing it the way they want to do it.
And Senator Curry, if you want to add anything, but I also wanted to ask if you're pleased with how Article 1, Section 27 is now being used. Were you disappointed during the 42 years when it wasn't properly being interpreted? So where are we sort of today, and how are you feeling about the way it's been enforced?
Well, I feel pretty good about it since the Robinson Township Delaware Riverkeeper's case and PEDF case, the fact that lawyers like John Smith are out there fighting. I give you a good feeling. Look, those 40 years we were in the darkness there in the desert, I never gave up. In fact, I wrote a book during that time period. In the book, I talked about Article 1, Section 27 being in a state of repose almost. I said, that doesn't disturb me because courts will bring it back to life, just like the amendments to the U.S. Constitution. And I turned out to be right with Robinson Township and the other cases that came along. Now, I never get into cases how they will turn out under the Constitution. And I don't have any scorecard, but I think it's alive and well. The fact it's being litigated means that people have to pay attention to it. And that includes state legislators, because everybody who gets elected to office in Pennsylvania, whether you're a legislator or the governor or county commissioner, you cannot take office till you take the oath of office, which means you take an oath to uphold the Constitution. That means Article 1, Section 27. Now, I think most legislators take that seriously. There are, unfortunately, I think some who don't. And the problem is for the taxpayers and the people in those districts to confront those legislators and say, how do you feel about Article 1, Section 27? You're bound to carry it out.
John, anything to add?
And I agree with Franklin. And I think, he was such a big part of the Robinson Township Delaware Riverkeeper's case because the court looked to him, looked to see why this amendment was passed, and it was very helpful. And obviously, we don't get to where we are today without it. One thing I will tell you that's always irked me about that case that went back up, as you remember, that was what Franklin's talking about is Robinson 2, the plurality decision. It was remanded back to the Commonwealth Court and then went back up to the Pennsylvania Supreme Court. And as Maya recalls, under the law, the state legislators, just looking back to Article 1, Section 27, they put in the law that if there was a spill or release, the people on public water were to get notice of the spill or release. And we challenged that law on equal protection grounds. What about people on private well water, which is millions of people in the Commonwealth? And the Pennsylvania Supreme Court agreed and struck it down and found that it was violative of the Constitution, equal protection. But again, easily could have used Article 1, Section 27 as well there, of the people's right to clean water. But what the court did, which was unusual, was they, instead of knocking the whole notice provision down under Act 13, if you read the opinion, it gave the state legislatures a 6-month window, an invitation to fix it, to go in and create a law that says, hey, if there's a spill or release, obligate the industry and the DEP to tell people who are in the aquifer that their water, it could be coming their way. 6 months, the court said, and then this is going to be stricken. The legislature did nothing. To this day, did nothing. And so when you look at, well, what can we do under Article 1, Section 27 to ensure people's right to clean water? There is a case staring you right in the face, which was readily ignored.
Senator Curry, any final remarks from you?
Well, I feel first of all, I feel lucky enough to be alive 50 years later to see it all happen. When I ran for the House, I had no idea I would be involved with a constitutional amendment. But now it's on the books. I feel good about it. It's not perfect, but nothing is. And I feel good that there are lawyers like John Smith out there fighting for it. And I think everybody involved in affecting the environment is aware that they face prospective challenges under the amendment. And that's good, because prior to this time, they did not. They totally ignored it. So I don't want to go on. I could chase that rabbit around the Briar Patch all day by these coal companies treating streams like private sewers. But now that's gone. And we have there's a new order in Pennsylvania whereby you've got to consider the environment whenever you act to have an impact on it. And I feel very good about that.
Thank you so much for being with us today. And John, did you have any final remarks?
Nothing. I appreciate being included. Thank you all.
Well, thank you so much. And we're a little bit past the hour, so we appreciate everybody hanging in there with us, but we will be sharing the recording with everyone after the fact. And also wanted to mention that we had a committee that worked on this, and I just wanted to give credit to Diane Sipe, Rachel Mark, Colleen Burns, Molly Atz, and of course Maya Van Rossum, who was our great host today. Thank you all for joining. We hope that you'll share this widely with your legislators. Let them know that they need to be watching this and taking all the great information that you heard today to heart. And so with that, thanks once again. You can see in the chat how you can order Senator Curry's book and how you can order Maya Van Rossum's book. So thank you so much once again, and have a wonderful rest of your day. Thank you.
Thank you.
Thank you, Senator.